Prior appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, requesting the judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
But it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed?
Judicial bias.
Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
With no judicial bias, I just have a statement straight to me telling you didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers Judge Gene Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Prosecution against me this entire time. No one has made her answer.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
Absolutely means you. If you're agreeing with that, definitely means that you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against.
Welcome back to the courtroom, where patience meets defiance and logic meets chaos. Today's case features a returning sovereign citizen, someone who believes they're not bound by the same laws as everyone else, and the ever-iconic Judge Oakley, known for his razor-sharp patience and no-nonsense approach. What starts as a routine hearing quickly spirals into a verbal tug-of-war about jurisdiction, due process, and even collusion. But as you'll see, Judge Oakley is having none.
Any argument you make from there, I'm going to deny, because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was.
I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside on what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
It's a dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt.
My objections on the record to make my case.
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence and you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a problem.
And here we go, the classic sovereign citizen tactic, talking over the judge. These self-proclaimed sovereigns often believe they can out-talk the system using pseudo-legal language. But judges like Oakley have seen it all. Notice how calmly the judge tries to redirect him multiple times before issuing that first warning. That's not impatience, it's control. Judges have to maintain authority. And when someone keeps interrupting, it's not just disrespectful. It's contempt of court, punishable by fines or even jail time.
Again, you're trying to spin the stereotypes.
I'm not spinning.
My objection is based on you stopping you not allowing me to do it. And that's what you told me when you addressed me.
Okay. All right. So let's do it this way. Let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once admitted it's on the, why it's on the prosecutor to prove those things. There's the false words and irregularities.
All right. Let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to keep
Once again, you're not answering the question I asked. You just said you will not participate. And I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me being able to get all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
I'll like put on record that if whatever you would like to do from there, you can, because I'm open until these things. Like I say,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there was a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Please arrested Mr. Crusoe while he was in Huron Township, but if our district court has jurisdiction over offenses that occur within the township, both civil and criminal, this is criminal against focus.
Did you appeal Judge Green's decision on that motion?
I'm prosecuting because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
There it is, contempt number 1. And it happened so fast you might miss the brilliance of Judge Oakley's method. He doesn't yell. He doesn't lose composure. Instead, he educates through discipline. Every time a defendant refuses to answer a yes or no question, the judge calmly adds another $100 fine. It's part courtroom management, part teaching moment. You can hear Oakley's frustration masked in professionalism. I can do this all day. That's not bravado, it's experience.
Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they're submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, judge said that.
Fine. Then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
Okay.
Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant, because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection.
Here's where the judge delivers what might be one of the most underrated legal lessons ever. You can't argue with a ruling. You can only appeal it. Sovereign citizens often treat the courtroom like a debate club, thinking persistence equals victory. But the judge reminds him, this isn't about who talks louder. It's about who understands procedure. Notice Oakley's tone here. He genuinely tries to help. When he says, I've been trying to save you from yourself, it's not sarcasm. It's a warning. The law has a process, and ignoring it can turn a small infraction into a criminal charge real quick.
Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay.
Prosecutors.
Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Okay.
For example.
You use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything's taking place.
No.
Exactly.
No.
The courtroom tension peaks here. The defendant's objections have no legal basis, but he keeps throwing them out like verbal grenades. Judge Oakley takes the time to explain what an objection actually is, and this is pure gold for anyone learning about courtroom etiquette. You can't just yell objection because you disagree. There has to be a legal reason, like improper foundation or hearsay. When the judge says, your objections mean nothing to me, it sounds harsh, but he's absolutely right.
is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you noticed me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's why I should have tried and I emergency stop the motion to stop this.
I already ruled on that.
Circling back, acknowledge my motions for my next travel. Nothing to do.
Once again, I'm not trying to, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right? I am open-minded enough to think that perhaps my mindset about your whole travel thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep, each judge has done the same thing. They just keep setting it aside and acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my end.
What's your case that traveling doesn't mean operating?
I'm sad for the fact that this court's violated my due process rights in every way, the judicial bias and the
All right, then appeal me. But today we're having a jury trial.
stating an unlawful jury trial, and I think that weighty statement I need to get on the
All
record.
right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
Violates my rights to a fair trial. 100%. And you want to keep overlooking them. I know that makes you seem like they're not a big deal. And
No, your rights are a really big deal.
The defendant insists the judge has no authority because he didn't consent. But in law, jurisdiction isn't optional. It's defined by where the alleged offense occurred. The judge calmly breaks it down. The incident happened in the township of Huron, Michigan, and by law, this district court does have jurisdiction. The brilliance lies in Oakley's composure. He doesn't argue belief systems. He cites legal structure. This is what's separate authority from chaos. Facts over feelings, law over theory.
Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
rulings from the American jurisprudence sites that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this is something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process we're kind of,
Which is not an appeal.
is a extreme, lawyer when there's bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure.
Judge Oakley's tone shifts from firm to fatherly. I'd like to save you from what's going to happen today. This is a rare moment of empathy in a courtroom filled with tension. The judge explains that his rulings aren't personal, they're procedural. But the sovereign citizen still can't separate authority from bias, and that's the tragedy here. What could have been a routine hearing has become a full-blown meltdown. simply because one party refuses to recognize the system they're standing in.
Those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Crusoe, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me my weather days before any of this even happened and talked to us about the traveling. Even told me I was well within my rights. Gave me every clarification I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me. He even called me trying to arena. I was like, well, it's not an arena. And then he goes towards the motor vehicle. And then he tries to get me to not pursue legal matters. And then he gets mad at me. And then the day that I file for my body cam, I'm getting removed from here on a Little League.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, and every time I force it to make my case, the court keeps setting all my stuff and not allowing me to do it.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How can there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation.
And that's where we'll leave it. Yet another sovereign citizen convinced they can outsmart centuries of established law, and a judge forced to balance patience with authority. Judge Oakley handled this masterfully. Controlled tone, legal clarity, and consistent boundaries. The takeaway? The courtroom isn't a playground for personal beliefs. It's a place where structure and facts rule.